In a high-profile courtroom drama that has garnered international attention, today we delve into a case filled with both mystery and controversy. Kouri Richins, the Utah mother accused of poisoning her husband with a lethal dose of fentanyl, faces a litany of charges. The allegations claim she gave her husband Eric Richins a fatal dose of fentanyl in a drink the night he died. This narrative alone is captivating, but there's more to the story. Recent developments have thrown Kouri into the spotlight once again, this time due to allegations of witness tampering stemming from the Walk the Dog letter. Do you remember the Walk the Dog letter and the ensuing drama it has stirred? It all started when law enforcement stumbled upon this puzzling letter during a search of Kouri's cell. The search was initiated after Kouri was observed showing her mother a multi-page letter during a video call, urging her to read it quietly or capture a photo. Kouri made it clear that this letter was intended for her mother's eyes only. The letter appears to contain explicit instructions to Kouri's mother and brother on how to testify, a move that the state has vehemently alleged to be witness tampering. Yet, in a somewhat less than convincing performance, Kouri later spoke to her brother Ronnie during a jail call, claiming that the Walk the Dog letter was nothing more than the initial draft of a fictional story, a part of a 60-page book she had been diligently working on. Well, all of this fueled a series of legal maneuvers, sparking a flurry of motions and demands from both sides. Just last Friday, Kouri, alongside her legal team and the prosecutors, gathered in court to confront the issues stemming from the Walk the Dog letter and the subsequent legal motions, setting the stage for some intense courtroom debates. We're going to get into it, but first be sure to click the like button, subscribe to the channel, and hit the notification bell so you don't miss out on updates to this story, trending true crime topics, and so much more. Now let's get into it. To understand the recent court appearance, let's do a Sleuthy summary of the case. Kouri Richins is charged with murdering her husband Eric by administering a lethal dose of fentanyl. Following her husband's tragic death, she authored a children's book on grief, meant for her 3 sons. Over the past couple of months, we've witnessed a shift in the case's focus. Kouri's recent jailhouse shenanigans have taken center stage. She's been busy authoring new tales, and this time she wrote what has affectionately become known as the infamous Walk the Dog letter. If you don't know what I'm talking about, you can get caught up here in Checkmate. This letter, directly addressing her mother while referring to her lawyer in the third person, is filled with explicit instructions for her mother to guide her brother on how to testify. What's particularly intriguing is that when this letter was uncovered, Kouri's explanation was that it constituted a chapter within her 60-page fictional mystery novel. But Kouri's claim that the letter was part of her book has prompted the prosecution to demand Kouri's lawyer surrender the remaining pages. And their request goes beyond this. They also seek the elusive multi-page letter that mysteriously disappeared from Kouri's cell after she displayed it to her mother during the video call.
That's the court's position. They've only made that as it relates to the 60 pages, not the entire packet.
I agree.
So,
Are we talking about the entire package?
well, it was unclear to
Mr.
me.
Nate says yes.
Yes, I was asked to turn over the entire packet.
Is that accurate, Mr. Woodworth? I thought the briefing was I agreed to turn over the 60-page document and upon reflection I
And
can't do
then
that.
it was further requested that I give the packet to the review attorney. And the problem
Did I
with that,
Mr. Nate? It's okay, you're I apologize.
the problem with that is I can't, once I assert a privilege, I can't turn it over or I waive the privilege,
Understood.
and I can't turn over a part of it. So I guess what I need from the court today is an order telling me I need to turn over the 60 pages. If that's what the court's inclined to do.
No, I'm inclined to not do that.
Well,
So
if I
let's
need to, do I
let's
need
take
to-
a step
okay.
back. I understood, Mr. Bloodworth, that we were talking about the document, not the folder.
Your Honor, there's letter number 2.
So that's what she held up?
This is the one she held up.
Okay.
And then 60 or so pages of what she describes as the continuation of the walk the dog fictional narrative.
Okay. Are those the two documents you're talking about?
Yes, Your Honor. We don't know what else is in there to make a good cause showing.
Well, that's the way it goes, though, when people are handing an attorney-client privilege or a marked folder their attorney.
Well, yes, Your Honor, but when removal of the material from the jail violates jail policy, that adds another wrinkle to it.
Let's stay focused on the two documents. I don't have enough to speculate about what may have been in or not in that folder, and now I understand the significance of Ms. Lazaro telling me jail staff went through the folder several times. Now I understand where you were headed with that. Let's stay focused on just the two documents. The one page that was held up, which the vernacular for that is letter number 2.
The vernacular is letter number 2, Your Honor. It was multiple pages.
Okay. And then the 60-ish page document.
Correct.
But before any materials can be handed over, a critical matter must be addressed: assessing whether the contents of the folder, which includes both the 60-page book and the multi-page letter, also contains documents protected by attorney-client privilege. Consequently, the court has devised a plan to appoint an impartial attorney to review the folder's contents before granting access to its contents.
This case is very high stakes. It's an aggravated felony. It has enormous amounts of attention. I don't want to make this decision without the benefit of the adversarial process. So we're going to use belt and suspenders on this one. Have you determined, Mr. Bloodworth, who is going to represent the state in this process?
Your Honor, not by name.
Okay.
We can, but the state will select somebody at short order to serve as the state's advocate in this process.
I appreciate that. What I'm inclined to do is order counsel to be confer regarding the terms of an order that will control how this process unfolds. It states in black and white who is allowed to have access and not allowed to have access to the 60-page document in letter number 2, and then hopefully provide some deadlines for submitting the 2 documents to the state's shielded attorney and briefing deadlines for getting it before the court. Does that sound reasonable, Ms. Listener?
Yes.
Mr. Bloodworth?
Yes, Your Honor.
That is the state's order.
Right after the discovery of the Walk the Dog letter, prosecutors promptly leveled allegations of witness tampering against Kouri. They wasted no time in petitioning the judge for a no-contact order to bar Kouri from any communication with her mother and brother until the trial, aiming to thwart any further witness tampering.
Your Honor, in a sense, the court has its hands on the dial. And if it turns the dial in one direction, it can amplify the protection against witness tampering in this case. If it turns the dial...
Assuming any has occurred, right?
I'm going forward.
Okay, fair enough.
Going forward.
Yeah.
If the court were to rotate the dial in the other direction, it could more narrowly tailor the prior restraint. And they're correlated, right? So if you amplify the protection, you're going to have a much broader prior restraint. And so when the state first asked for the no contact order, a lot of water under the bridge since then. When the state first asked for the no contact order, it asked for a lot of protection against future witness tampering. Which also meant that prior restraint wasn't very much. I think we're at a point now, having all learned a little bit of a briefing and argument before today, based on where we stand now, the state would kind of adjust the dial, accept some risk to future witness tampering in order to more narrowly tailor prior restraint. And I recommend, to accomplish all of that, to include the necessary communication you referenced in your question. I think a more reasonable and appropriate order reads something like this: that the defendant shall have no contact with her mother Lisa and her brother Ronnie regarding the criminal case outside the presence of counsel. That would allow any necessary contact to prepare. That would allow necessary conduct with her mother and brother to prepare her defense, but it would place counsel there to ensure that it was just preparing.
This did not sit well with the defense. They followed with accusations that the search was illegal and that the state should be sanctioned for violating the gag order imposed by the judge. They asserted that the letter was found in an envelope marked attorney-client privilege. But Kouri's predicament wasn't solely a result of her written words when the letter came to light. It was also her spoken words later that day during a recorded jail call with her brother Ronnie. During the conversation, she asserted that the letter wasn't a set of instructions, but rather a chapter within a 60-page fictional mystery novel she had been diligently working on. Unfortunately, the characters in her story remained all too real. Regrettably, it was that very conversation with her brother that provided prosecutors with the ammunition they needed to insist on obtaining the remaining pages of the self-proclaimed fictional mystery novel, which they believe to be in the possession of her lawyer. But their demands extend beyond the 60-page manuscript. They also seek the elusive multi-page letter that had mysteriously vanished from Kouri's cell after she shared it with her mother. Well, Kouri's defense team raised a motion citing prosecutorial misconduct and an illegal search that led to the discovery of the Walk the Dog letter. Kouri's defense lawyer says that the letter wasn't found where the sheriff claimed it was. She says it was in an envelope clearly marked attorney-client privilege. She also alleges that the prosecutors breached the gag order by filing the letter with the court in the manner they did. Attorney Lazaro claimed that the prosecutors independently filed the Walk the Dog letter using a title designed to attract media attention. Attorney Sky Lazaro, in a bold move, pushed for sanctions against the prosecutors for their perceived violation.
I want to address first is the rules are clear about what they can and can't do. And the rules are clear about prosecutors in particular, what they can and can't do. And they have a heightened duty. And there's case law out there that specifically says they have this heightened duty because things that come from the government come with more indicia of credibility, right? If the government's saying she's a liar and the witnesses are liars and any theory she has of the case is a false narrative because it doesn't fit theirs, that's a violation of the rules. Like, period, I think. Or at least that's our position, is they have clearly violated the rules in doing that. And in going so far as to make statements about her guilt. There's been a violation of the rules.
In a subsequent motion, Attorney Lazaro requested the dismissal of all charges. The argument was based on the notion that the surge of media coverage has rendered it impossible for Kouri to receive a fair trial. Moreover, she contended that the credibility of every potential defense witness she intends to put on the stand has been severely compromised.
And the ABA comments speak directly to it. And it's 8-2 points. 1 second. Time to get there. I can only remember so many numbers. Point 1. And what it says is a lawyer participating in a criminal matter should not place statements or evidence into the court record or into a document that is deemed an open record under applicable law solely for the purpose of circumventing the standard. if the lawyer has reason to believe that the public release of the record or document would create a substantial probability of harm to the fairness of a trial or other overriding interest, the lawyer should consider seeking a sealing order pursuant to standard.
Pause there for a minute. In order for a violation of the rules to be material, it has to have caused irreparable prejudice such that due process is violated, she can't get it for trial. So let's stay focused there. I'm just not sure we're at that point, given the amount of publicity that existed beforehand, what the comments probably said before all of this, the availability of other measures. Dismissal is the ultimate sanction. And correct me if I'm wrong, I don't think you cited a case in which the case was dismissed prior to trial for this kind of conduct rather than during trial. Am I right about that?
Or after.
Okay.
Correct. But the issue is that they have just declared that she's guilty of it, right? Instead of.
Is there anybody in the world that thinks the state of Utah doesn't believe she's guilty of the crimes for which she's been charged?
Is there anybody in the state of Utah? Well, I hope so.
Well, I guess, no, not that they believe personally, but that does anybody out there think the state is just doing this as theater? I mean, the state's position from the beginning is she's guilty.
Right.
I don't think they've been unclear about that.
No, but the problem is that they've used, the way they've drawn the inference between witness tampering and the ultimate decision that a jury is going to make in this case after it hears evidence is that because she witness tampered is a consciousness of guilt. You know, she induced people to lie because she's guilty, right?
Isn't that similar to some of the arguments that we heard on which I relied during the detention hearing regarding the internet searches? Consciousness of guilt, trying to hide conduct.
Now for the judge's rulings on the matter of the no contact order.
The issue before the court is the state's motion for no contact order that seeks an order preventing defendant from having any contact with her mother or brother to prevent further tampering with testimony. The state has narrowed the relief it requests today at oral argument to say that defendant should have all in-person, or request that defendant have all in-person meetings with her mother or brother with counsel present, and that other communications be monitored in specific ways through technology available at the jail. First, the defendant has a First Amendment right and to correspond with whom she pleases and to say what she likes as long as she doesn't do anything that requires a prior restraint justified by a sufficiently strong interest that countervails her First Amendment rights. Here, there's no evidence that she's done any such thing that requires her to be prohibited from speaking to any specific human being. The Walk the Dog letters have several plausible readings. It does not include any threats whatsoever or any other kind of communication that would typically justify a prior restraint on free speech. Moreover, there's no evidence that it was ever handed to anyone. And the state hasn't. So to the extent they need to cross-examine a witness or impeach a witness with its contents at trial, they would be able to do so absent some other ruling by the court excluding the letter or suppressing the search that's found. Moreover, the status quo is that defendants' communications with everyone except her lawyer are monitored. They're recorded. And the court's in no position to make that job easier for the state. So the court is simply not presented with a sufficient basis to restrain Ms. Richins' First Amendment rights. The motion for no contact order is respectfully denied.
The judge expressed his intention to refrain from making it any easier for the state to monitor Kouri's communications. He noted that with all the existing systems in place, they should have no difficulty monitoring her effectively. Regarding the request for sanctions, here's what the judge ruled.
Ms. Lazaro, the motion to enforce order for contempt sanctions by sufficiently addressed that in reaching the conclusion on the motion for prosecutorial misconduct?
Yes.
Okay. The court is hereby denying the defendant's motion to enforce order and for contempt sanctions based on the same reasoning that justified the denial of the motion for dismissal based upon prosecutorial misconduct.
Judge Mrazek believed that the prosecution's actions did not reach the threshold necessary for sanctions. On the motion to dismiss,
The issue before the court is defendant's motion to dismiss due to prosecutorial misconduct. The gravamen of defendant's motion is that due to conduct by the Summit County Attorney's Office, defendant has been denied due process and her right to a fair trial. Specifically, defendant asserts that statements made by the Summit County Attorney's Office in briefing related to the walk the dog letter, briefing related to the Summit County Attorney's Office request for further limitations on Ms. Richins' ability to speak with her family members, have included statements that violate Rules 3.4 and 3.8 of the model and Utah Rules of Professional Conduct. Those statements include things like, quote, defendant is engaging in witness tampering or needs to be prevented from further engaging in witness tampering. The motion for no contact was based on the defendant's witness tampering and breach of jail security procedures. The walk the dog letter illustrates the defendant's consciousness of guilt with respect to certain explanations made by the defense for certain actions that no such link exists in the evidence, that defendant concocts a false narrative, that defendant's own handwriting she attempts to induce her brother to testify falsely, that she is facilitating witness tampering and supporting a false factual narrative, that she is giving her mother instructions to induce her brother to testify falsely, that this may indeed not be the first time the defendant witnessed tampering, and that defendant is making a frantic, dishonest attempt to explain how fentanyl came to be involved in this case. When viewed in isolation, these comments raise concern that they would cause undue prejudice by tainting the view of potential jurors in Summit County, the state of Utah, nationally, internationally, regarding Ms. Richins, her credibility of her counsel, and her ability to defend herself in a fair jury trial. But when read in context, and given how these comments are anchored to evidence in the record and motions made by the parties, these comments are within the bounds of professional conduct under Rules 3.4 and 3.8. These are examples of permissible advocacy on behalf of the state in support of its request for things like further limitations on Ms. Richins' ability to discuss, contact, correspond with certain family members, and also in response to arguments made by defense counsel related to other litigation topics. Moreover, before this issue arose relatively recently, this case had already received an inordinate amount of media attention, an amount so large that it is frankly not in the interest of justice. But the First Amendment works the way it works, and I can't prevent that. What the court can do and require counsel for the defense and the state to engage in is measures to mitigate any potential harm from publicity regarding the advocacy in this case on a going forward basis. And that would include careful, lengthy, and detailed voir dire jury selection. we will need to identify jurors that do not have any preconceived notions about the subject matter of this case or any of the people involved in it, parties, counsel, witnesses, etc. That may be a lengthy task, but it was made lengthy long before this issue arose, given pre-existing publicity regarding this case. Moreover, these arguments would have been appropriate and without objection, the court expects, had Ms. Richins actually been charged with witness tampering. In that situation, the court would be making determinations about whether or not there was probable cause for the charge and there was probable cause to bind her over for trial. And these very same arguments regarding potential consciousness of guilt and materiality of the letter would have been made and would have been wholly appropriate. Here, based upon the briefing currently before it, the court simply isn't persuaded that the conduct at the Summit County Attorney's Office violates Rules 3.4 or 3.8, or has caused Ms. Richins a denial of due process or a denial of a right to a fair trial. The court is confident that it can preside over a sufficient or dire process to ensure that Ms. Richins does in fact receive a fair trial. For these reasons, the defendant's motion to dismiss due to prosecutorial misconduct is denied.
Judge Mrazek affirms his willingness to guarantee the selection of an appropriate jury, ensuring that Kouri receives a fair trial. Despite the judge's commitment to a lengthy and exhaustive jury selection process, Kouri's legal counsel remains resolute in her quest to change the trial's venue.
And I granted dismissal is the ultimate remedy, right? But there are alternatives. I don't think any court here is going to cure this issue given the egregiousness of the statement.
So I looked at the defense's proposed alternative remedies. I'm not prejudging a motion to change venue, but you haven't provided a basis to change venue. The dynamics that we're talking about, as far as I can tell, exist statewide, nationwide. This case was covered by the BBC. I don't know that you will find a jurisdiction that is, certainly not the state of Utah, that is going to be materially different than Summit County in terms of its saturation with media coverage of this case.
Correct. I think there will be other grounds, and that motion will come. We're fairly early in the process of this, so I do anticipate moving for a change of venue. Based on, I agree, unless we're going to some tribal land in Ghana, we're probably not finding people where it hasn't touched. But I think there are other issues that we will bring to the court's attention that we believe would support a change of venue. We don't need to get into that today, but I do anticipate that will be coming.
Attorney Lazaro made it clear, leaving no room for doubt, that the walk the dog letter has not only thrown a wrench into her defense strategy, but according to her, the media sees the letter as not just evidence of Kouri's consciousness of guilt, but also suggests her involvement in potentially illicit activities as well. The attorney is concerned that the prevailing sentiment has already led to a near consensus on Kouri's guilt, rendering a fair trial seemingly impossible.
The state, in their assertions and the statements they have made, have not done that. And the prejudice is we can't undo that, okay? This letter is out there forever, right? Whether it's ultimately admissible at trial, doesn't matter. At this point,
it matters a little bit, doesn't it? Because if it were to come
I'm going to argue it matters because I'll probably move to motion to suppress it, but...
Well, sure.
Right.
So, I'm not expressing an opinion one way or the other on any kind of motion in that regard. But imagine the letter came in a trial. Any pretrial prejudice is now mooted. It's in. The actual jurors have seen it and heard it.
The problem is the statements the state has made during the pretrial phase, right? The statements that they have interpreted, this letter's open to multiple interpretations,
Sure.
right? And yes, we can get to that through cross-examination and
If it comes in.
at trial.
Right.
The problem is that there is local, national, global media where the state has interpreted the letter in the way they want and has put out to the world and all of our potential jurors that Kouri's lying, that her witnesses are lying, that her theory is false, that's the problem. The problem is their statements and the way they've interpreted it, and the prejudice to her is, you can't undo that. I mean, sure, we can probably ask people, questions in voir dire, but I don't think that's sufficient given the egregiousness of the statements. If it had just been, the way it should, in my opinion, the way it should have been done, or the defense's assertion is they could have moved the court for a motion for no contact order. They could have filed it under seal. They could have filed the letter under seal. We could have had this argument, or in a way that wasn't the state saying that she witness tampered. It wasn't the state saying that her witnesses lied. It wasn't the state saying she's guilty of murder. Those are the problems, and those aren't going to go away. Forever there's going to be this issue that the states said that, and they can't do that.
This case is undeniably dramatic. As the courtroom drama continues to unfold, the future for Kouri Richins remains uncertain. The legal battles stemming from her alleged involvement in her husband's demise and the subsequent publication of a children's book are already complex. However, the complexities have been further compounded by her recent actions. What's your take on this? Do you think the judge's rulings have been fair? Do you believe that the Walk the Dog letter demonstrates Kouri's consciousness of guilt? How about her chances of receiving a fair trial, considering the extensive international media coverage of the case? Do you think it's possible? Let's continue the conversation down in the comments section below. As always, I'll meet you there.